Hi, I'm Peter Hearty with Hearty Law. In this video, I'll look at some of the issues surrounding changing a spousal support order that is already in place. Spousal support is often one of the most contentious issues in any divorce or separation proceeding. The person paying often thinks they're paying too much or for too long or shouldn't pay anything. The person receiving often thinks they're not receiving enough or not being paid enough or compensated enough for the disparity or differences between incomes as a result of the marriage. Once a court order is in place, ordering spousal support for a period of time, either on an indefinite basis or on a specified duration basis, it is possible to change that order. But doing so, you need to address a couple of key facts. The biggest hurdle to get over if you wish to change your spousal support order is whether there's been a material change in circumstance. Previously, this was thought somewhat of a foreseeability. If you could foresee what was going to happen at the time the initial order was made, then you wouldn't change this. I think the case law has evolved a little bit since then. So really, the issue is if the information was known at the time, or if the information was before the judge at the time, would it result in something different? The best way to look at this is something like retirement. Well, everybody could foresee retirement, but that's not the issue here. So when you obtain your order at, let's say, age 40, and 20 years later you're still paying spousal support, but you're retiring come age 60, then that is a material change in circumstance. Even though you could have foreseen that you would have been retiring, or the person would have retired, it still is a material change in reducing the income. Other common changes that you're going to see are things like medical issues. A cancer diagnosis that impacts your ability to work or your ability to earn an income. That's a significant change. And something that you're going to be able to establish is a material change to what was known at the time. Once you've established a material change in circumstance, the next issue that the judge or justice needs to resolve is, now that we know this information, how does that change the order that currently exists? So this does not mean start from scratch and restart the entire process, the basis for which spousal support was granted in the first place. All of that information still exists. The very narrow issue that needs to be resolved is, how does this specific change that, even if foreseen, wasn't in place or wasn't effective at the time, how does that change the spousal support that's currently being paid? Again, let's go to retirement. So if your income is reduced in retirement, well, that's a pretty significant change, and we incorporate that change into a new order. Does it mean, based on new incomes and information exchanged between the parties, that there really is no longer any spousal support ordered? Not an easy question to answer. But retirement also brings up a very interesting point in relation to finances for retirement. That's pensions. So if during your divorce and separation proceedings, your pension was divided, went through the proper process, pension was divided, and for this example, let's say pension was divided 50-50. Well, that's property at the time, and it was divided equally between the spouses. Now come retirement time, and the spouse with the pension retires, and his pension goes into pay, or her pension goes into pay, and that creates an income stream. Well, what you can't do is for spouse A to give up 50% of the pension at time of divorce, and then come retirement, give up 50% of the 50% that was taken to cover spousal support payments. This concept is called double dipping. So if you've already given up half your pension, you can't give up another half in the income stream. That half was already given up, that half was already accounted for, and everybody dealt with that specific issue at the time of divorce. The other important consideration here is duration of spousal support. So you may have heard a 65 factor. So the age of the spouse receiving the support plus the duration of the relationship, if that's over 65, then spousal support is indefinite. This does not mean permanent, just means there's no specified end date on the spousal support. It's the same thing when the relationship exceeds 20 years. Spousal support is indefinite, not permanent, indefinite. So all of these sort of issues you need to reevaluate and reexamine, and what should or what is the proper end date for the spousal support. A lot of times it's some sort of step down. So if you're receiving $1,000 a month right now in spousal support and have been for the last 10 years, well, going to zero is a pretty significant change. But if for a year it dropped to $750 a month or $500 a month, the following year dropped again to $200 or $250 a month, and then a termination, that's likely a potential outcome. So if you've been awarded spousal support on an indefinite basis, or you're paying spousal support on an indefinite basis, that does not mean permanent. The most important thing to keep in mind here is that spousal support is a very complex issue. A very complex issue financially, and a very complex issue emotionally. Don't go through this alone, or don't think you have to go through this alone. If you've got any questions related to spousal support, changing a current order, ending a current order, or examining your legal options in relation to what you're currently paying for spousal support, please contact Hearty Law today for a consultation.